Welcome back to the deep end. We are doing something a little different today. Usually we take a topic and look at the cultural or scientific implications. But today we're looking at the operating system of society itself.
That's a good way to put it.
We're digging into the first two chapters of Civil Litigation, 8th edition. And before you reach for the skip button, because, that sounds like law school homework, let me frame the mission here.
It's a fair warning, but I think the skepticism vanishes the moment you realize what this text actually is. It's not just a manual for lawyers.
Yeah.
It is the rule book for how power is negotiated when the polite conversation ends.
That's the angle that grabbed me. We all have this mental image of court derived from these high-stakes TV dramas. The surprise witness bursts through the doors, the judge is banging the gavel every 5 seconds.
Objection. Overruled.
Exactly. And the whole thing is wrapped up with a nice moral lesson in under an hour. But looking at these chapters, the reality is almost diametrically opposed to that.
It is. The reality of civil litigation is that it is a highly structured, intensely strategic, I'd almost call it a war of attrition. And it's almost entirely fought on paper long before anyone even thinks about entering a courtroom.
Right.
In fact, if you are doing it right, or depending on your perspective, wrong, you might never see the inside of a courtroom at all.
And that's the deep dive today. We aren't just summarizing a textbook. We are trying to understand the architecture of dispute resolution. We're going to look at the massive chasm between civil and criminal law, which is way more nuanced than just jail versus money.
Oh, much more.
We're going to walk through the life cycle of a lawsuit, the actual roadmap from the moment a client walks in the door to the final appeal. And we are going to spend a significant amount of time on what feels like the boss level of the legal system.
Jurisdiction.
Jurisdiction is where the real 4D chess happens. It's so easy to gloss over it as just which court, but as we'll see with cases like International Shoe or the more recent Bristol-Myers Squibb, understanding jurisdiction is understanding the limits of state power over the individual. And we're going to do this while integrating the role of the paralegal, who the text essentially identifies as the engineer keeping this massive machine from overheating.
Absolutely. The unsung hero.
So let's start with the fundamental definition. We are talking about civil litigation. If I'm a business owner or just a guy who got rear-ended at a stoplight, why do I need to understand the distinction between this and the criminal system?
Because the mechanism of justice, the rules, the stakes, everything changes completely depending on which lane you are in. The text defines civil litigation as the resolution of private disputes between parties.
Private being the key word there.
The key word, it's not the state versus a citizen. It is citizen versus citizen, or corporation versus person, or business versus business.
The text uses this example, Lombardi v. McNair, as an anchor. It's a really simple setup. Lombardi lends McNair $1,000.
A simple loan.
McNair signs a promissory note, which is basically an IOU. 3 months later, the note comes due, and McNair, in a move we've all seen from that one friend, refuses to pay.
Right. And this brings us to the first major fork in the road. Lombardi is angry. He's out $1,000. His instinct might be to call the police.
He stole my money.
Exactly. But if he does, the police will tell him, "Sir, this is a civil matter."
Because owing money isn't a crime. It's not theft in the legal sense.
Precisely. Unless there was some kind of fraud involved from the very beginning, like McNair never intended to pay it back, and it's all a scam, a simple breach of contract is a private wrong, not a public one.
So in the criminal system, the victim isn't even really the one driving the case.
That's a critical distinction. The victim is a witness, a key witness. But the party bringing the suit is the government, the people of the state of California, the United States of America against the defendant.
And the objective there is punishment.
Yes. Society, through the government, is saying, we cannot tolerate this behavior, so we are going to punish you. We're going to fine you, put you on probation, or strip you of your liberty.
Whereas in our Lombardi v. McNair case,
Right.
the government doesn't really care if McNair is a flake.
The government is a neutral referee. They provide the venue, the court system, the judge, but they don't have a dog in the fight. The objective in civil law is compensation, not punishment. Lombardi doesn't want McNair in handcuffs. He wants his $1,000 back, probably plus interest and his court costs.
This leads to the different standards of proof, which I think is often the most confusing part for the layperson. We are so conditioned by TV to hear beyond a reasonable doubt.
Which is an incredibly high bar, and it should be.
Right.
If the state is going to lock a human being in a cage, They need to be, 98, 99% sure. Any real rational doubt, and the defendant has to be acquitted.
But in civil litigation, because we're only talking about money or property, the standard is much lower. It's the preponderance of the evidence.
Which is just a fancy way of saying more likely than
That's
not.
51%.
That's it. If the jury or the judge looks at all the evidence in the Lombardi case and thinks, well, it's slightly more likely that McNair owes this money than that he doesn't, then Lombardi wins everything. The scale just has to tip, even slightly.
That distinction is why you see those paradoxical outcomes in really famous cases. The O.J. Simpson saga is the classic example, right?
It's the perfect illustration of this principle in action.
He's acquitted in criminal court.
Because the criminal jury looked at the mountain of evidence and said, we have a reasonable doubt. Maybe they were 80% sure he did it, but that 20% of doubt, that's the reasonable doubt, and it saved him from prison.
But then the victims' families sued him in civil court.
They sued him for wrongful death, a civil claim. The civil jury looked at mostly the same evidence, and the question was different. It wasn't, are we 99% sure? It was, is it more likely than not that he was responsible?
51%.
And that jury said yes. So he was found liable, not guilty, but liable, and was ordered to pay millions.
And that doesn't violate double jeopardy.
Great question. No, it doesn't. The double jeopardy clause of the Constitution protects you from being tried twice by the government for the same crime.
For the crime.
But it doesn't protect you from being sued civilly by a private party for the actions that constituted that crime. They're two different systems with different goals and different standards.
There's another nuance here that the text points out regarding appeals. In the criminal system, if the defendant is acquitted, the prosecution can't just say, darn, let's try again, we want a do-over.
Correct. Once a jury says not guilty, the state is barred from appealing that verdict. That's it. It's over. Again, that's part of the double jeopardy protection. You can't just keep trying a person until you get a conviction.
But in civil litigation, it's a level playing field.
Totally level. If Lombardi loses his case against McNair, he can appeal. If McNair loses, he can appeal. The system views the parties as